Hello everyone, today we are reflecting on the lessons learnt from the public sector off-payroll rules that were implemented in 2017 and how agencies supplying private sector end clients can avoid some of the same pitfalls in the run-up to April 2021. We've done a separate video on the lessons learnt aimed at end clients, but actually understanding those issues will help agencies as well, so I do recommend you check that video out too. But let's carry on with today's content now. So how were agencies most impacted by the public sector changes? I think the most important lesson was that agencies really paid the price for bad decisions made by their clients. One example would be PSC contractors terminating or not renewing assignments because they've been deemed inside IR35 and they simply couldn't afford to stay in the same assignment with that significantly reduced take-home pay. Well, that agency lost its margin on those contractors. Another was the kind of indirect or reflected reputational damage. Public authorities who issued blanket bans or blanket determinations, they encountered significant backlash from the contracting community. And agencies who supplied PSCs to those public sector clients were often caught in the middle and tarred with the same brush, even though they had no control over the client's decision making. Where assignments were deemed inside IR35, the additional statutory costs to agencies often couldn't be recharged to clients, and therefore those agencies had to sacrifice a lot of their margins in order to make those payments. Certainly, the entire public sector has experienced increased time to fill roles, and with authorities who'd made poor decisions about how to manage the legislation finding those longest lead times. While agencies who work with those clients and source for the roles at those clients, they've had to work much, much harder to find willing candidates to fill those roles. And that increased time and workload to fill those roles makes the placements less profitable for agencies. The one piece of good news, especially for agencies working in financial services or any of the other industries who have openly blanket banned PSCs going forward, is that clients do change their minds. Once the insanity of the initial implementation period has passed, we will see clients who have banned PSCs or used very poor assessment tools such as CEST change their approach and assess using better quality methodologies. Honestly, I'm absolutely convinced of it. Because private sector clients, unlike the public sector, have competitors. And if those competitors invest in expert assessors, make lots of changes in their organisation to treat contractors as they should be treated, well, they might have up to 50% more roles deemed outside IR35 than a similar company who's used CEST or whatever. That's a huge competitive advantage. That client will be able to attract the very best talent, able to pay lower rates, and they'll retain those top quality contractors as well. Conversely, the clients who have banned PSCs or taken some kind of similar approach, they will lose out. They'll only attract the most desperate contractors. They'll pay a lot more for them, and they'll be reviled within the contractor community. Contractors working in roles that are inside IR35 will be constantly on the lookout for roles that are outside IR35 in other organisations, and they will leave their current assignment with no notice and no handover if they're offered a better role. Clients simply can't afford not to assess properly in the future. Another key takeaway from the public sector was kind of the lack of engagement and support for affected PSC contractors. And agencies can and should offset that reflected negative reputational damage that their clients might incur by making every effort to engage, inform, and support their contractors. You can't change a client's status determination, but you can influence how the contractor feels about how you've handled the situation. Remember, Contractors who are deemed inside IR35 are looking at a 20 to 25% reduction in what we call take-home pay. You need to be sensitive to that fact. Could you take a 25% pay cut and still pay all your bills? Not many can. So be empathic, supportive, and make sure you maintain an almost continuous dialogue with affected contractors. Even if the client isn't moving very quickly and you don't have any updates and you're not ready to issue status assessments, we'll find other content and material to send out to contractors. Issue surveys, put together infographics, anything to make them feel heard, understood, and let them see that even if the client is making bad decisions or reacting too slowly, you, their agency, is doing completely the opposite. Another consideration is the enormous growth in non-compliant umbrellas. So if a PSC is deemed inside IR35, they have to be moved to a pay-as-you-earn compliant model, whereby the contractor pays income tax and employees' national insurance, and the deemed employer pays employers' national insurance, and of course the apprenticeship levy as well. Most contractors will either be required or will prefer to move away from a PSC to an umbrella model. And it's a perfectly legitimate mechanism when it's truly compliant. But it's important to remember that any non-compliance on the part of the umbrella can put you at risk under various tax legislation, such as the Onshore-Offshore Intermediaries and the Criminal Finances Act. So due diligence on umbrellas is absolutely crucial to make sure you don't just exchange one risk, PSCs, for another, umbrellas. We also saw a lot of confusion in the public sector over where the liabilities in the legislation lie. Now, the extended off-payroll rules that come into force in April and the associated guidance from HMRC does at least make this position slightly clearer, though I should add no fairer. Clients are liable unless and until they provide a valid SDS to you, the agency, and to the worker within specified timescales. So that is before a payment is made to the PSC for any work done after the 6th of April. The client must have used reasonable care when making the status assessment, and they also have an obligation to implement a status disagreement process with certain mandatory minimum requirements. That is pretty much the extent of their responsibilities. They won't be liable for any incorrect status determinations if they can show they have used reasonable care. You, as the fee payer, are liable. And that's a huge liability on you that you have almost no control over. And we've got a separate video all about that fee payer risk and how to mitigate it, so do check that out. The final lesson, or actually more of a question, is over employment rights. Now, IR35 is a test for tax treatment, not for rights entitlement. In theory, one does not impact the other, but they do use the same criteria or factors to determine status. The application and weighting of those factors is different depending on whether you are determining employment status for rights or for tax, but they are the same factors. And therefore there is a strong argument that if a contractor is deemed inside IR35, they could successfully argue for some employment rights. And we've got other content on the factors that determine status for both tax and rights if you want more detail about that. Now, it is possible to be employed for tax purposes, so inside IR35, and self-employed for rights purposes. And actually, HMRC expects that all contractors deemed inside IR35 have that status. But in reality, they could well be deemed to be a worker, which is a kind of hybrid status in employment law that doesn't exist in the tax regime. And in fact, a contractor has already used the employment tribunal route, but his aim wasn't to get worker rights. It was actually to try to prove he was self-employed for rights purposes in order to try to offset or argue against his inside IR35 status determination as issued by his public authority client. And I talk a bit more about this case in the lessons learnt video aimed at end clients. So combine this potential risk with all the recent case law around employment status for rights, think Uber, Deliveroo, Pimlico Plumbers, etc. I think it's something that agencies do need to be conscious of. So my advice to agencies is to do everything you can to get your clients moving and assessing their PSC workforce using an independent expert assessor who will provide correct status assessments. Communicate constantly with your contractors and make sure your umbrella partners comply with all their legal obligations. Doing all these things will genuinely mitigate against your financial, legal, and reputational risk. Thank you so much for watching.